Time will tell the story better than it ever could. That's the line most people skip past, because the internet didn't pause on context. It paused on emotion, on fragments, on a headline-ready interpretation that spread faster than the statement itself. So before anything else, we have to do one thing cleanly. Separate what was said from what was assumed. A few days after John Patrick Rourke was arrested, Eric Carroll posted a statement on his Facebook page. That post has since been circulated, paraphrased, reframed, and in some places, outright rewritten by commentary channels chasing attention. Some are now claiming the statement is an admission. Some are framing it as guilt by implication. Some are presenting it as confirmation of long-running theories. But if we're going to handle this responsibly, we have to start with the actual substance, not the click-friendly label being attached to it. Carroll's post does not say, "I committed a crime." It does not say, "I took money." It does not say, "I participated in fraud." What it does say is something far more common and far more dangerous to misinterpret. It says he feels crushed by accusations he claims are false. It says he has been threatened and harassed. It says his children have been pulled into a public storm they did not ask for. It says he reported concerns in the past and felt ignored. It says he cannot speak freely now. And it says explicitly that time, not social media, will determine the truth. That is not an admission of guilt. That is a statement of constraint. And that distinction matters more than ever, because we are now in the phase where words themselves can become evidence or misused as if they are. Let's slow this down. In active or adjacent legal matters, silence is not optional. It's often required. Attorneys routinely instruct clients not to comment, not because comments are incriminating, but because any public statement can be reframed, excerpted, or weaponized later. That's not theory. That's practice. So when someone says, "I can't tell you anything," that doesn't signal knowledge of wrongdoing. It signals awareness of risk. And when someone says accusations are out of control, that doesn't equal denial or confession. It's a recognition of how fast unverified claims spread once a case becomes public. The problem is that nuance doesn't travel well online. What travels is a headline like, "Eric Carroll says I'm guilty," except that's not what he said. That framing is an interpretation layered on top of the statement, not something contained within it. And this is where harm begins. Because in the court of public opinion, emotional language is often treated as evidentiary language. Vulnerability is treated as confession. Exhaustion is treated as exposure. But legally, none of that holds. Courts do not infer guilt from distress. Investigators do not treat Facebook posts as admissions unless they explicitly contain them. And prosecutors do not file charges based on tone. They file charges based on proof. Which brings us to the timing of the statement. This post appeared after Patrick's arrest. That timing matters. Not because it implies involvement, but because it changes the risk profile for anyone tangentially connected to the case. Once an arrest occurs, everything shifts. Statements that might have been benign weeks earlier become liabilities. Silence becomes strategy, and emotional responses become targets. So when Carroll writes that he is not allowed to tell you anything, that is consistent with someone who understands that the legal environment has changed, not someone confessing to wrongdoing. Now, let's address the other piece that's being spun aggressively. The claim that Carroll is admitting guilt because he expresses regret, frustration, or emotional burden. That's a misread and a dangerous one. People under public accusation often internalize shame even when accusations are false. That's not guilt in the legal sense. That's psychological pressure. And here's the part people ignore. Carroll explicitly says he reported concerns in the past and felt unheard. That detail doesn't prove anything. But it also doesn't align neatly with the idea of someone quietly complicit and now confessing. It suggests someone who believes they tried to intervene and are now being blamed anyway. Is that true? We don't know. And that's the point. Knowing what's true requires evidence, not inference. Now let's talk about what hasn't happened. As of now, Carroll has not been charged. He has not been arrested. He has not been named as a defendant in any filed case. That doesn't mean he never will be, and it doesn't mean he won't be questioned. But it does mean that, legally, he stands where many people do in high-profile cases, under scrutiny, not under indictment. And that distinction is not semantic. It's foundational. The law does not operate on implication. It operates on thresholds, probable cause, charging standards, evidentiary sufficiency. A Facebook post, even an emotional one, does not meet those thresholds. Now let's address the speculation around Patrick's custody status, because this is where rumor has fully outrun record. There has been widespread assumption that Patrick would be released on bond on Tuesday. That did not happen, and immediately theories filled the gap. Unsupervised probation, violation holds, prior charges resurfacing. Some of these theories could be plausible in general terms. But here's the key word, could. Without court documentation confirming probation status, conditions, or holds, all of this remains speculation. Probation violations are serious, yes. But not every arrest triggers automatic detention. And not every detention is explained publicly in real time. Again, silence is not confirmation. And this is where responsible coverage draws a hard line. We do not fill gaps with assumptions. We do not declare legal conclusions without filings. And we do not turn personal statements into confessions because they fit a narrative. Which brings us back to the damage Carroll describes. Threats, harassment, children being targeted. Those things do not advance justice. They undermine it. Dragging uninvolved family members into an active legal situation does not help victims. It does not help investigations. And it does not help truth emerge faster. It only guarantees collateral harm. And here's the uncomfortable reality. In high-attention cases, the loudest accusations often come before the strongest evidence. That doesn't make them correct. It makes them early. And early certainty is often wrong. So where does this leave us at the end of part 1? With boundaries. We have a statement. We do not have an admission. We have an arrest. We do not have convictions. We have speculation about probation. We do not have confirmation. And we have a growing pattern of commentary that blurs all of that together for clicks. That's not analysis. That's acceleration. In part 2, we're going to do what most coverage won't. We're going to break down what Carroll's legal position actually is right now, what it means to be uncharged but discussed, what investigators can and cannot do at this stage, and why silence is not the signal people think it is. Because understanding this case requires resisting the urge to turn every word into proof. Truth doesn't rush. Noise does. And the difference matters. Right now, there's a dangerous shortcut happening in the public conversation. People are treating attention as evidence. They're treating proximity as participation, silence as confession, emotion as admission, and none of that survives contact with the law. So let's slow this down and talk about what it actually means legally to be uncharged but discussed in a case like this. Because that category exists, and it exists for a reason. As of now, Eric Carroll has not been arrested. He has not been charged. He has not been named as a defendant in any public filing connected to the Whittaker investigation. That does not make him invisible to investigators, but it does define his position. And that position is narrower than most people online are pretending. Being uncharged means one thing and one thing only. Prosecutors have not crossed the legal threshold required to accuse him of a crime in court. That threshold is not suspicion. It is not rumor. It is not collective certainty. It is probable cause tied to specific statutory elements. Until that exists, the law treats Carroll as what he is, a private citizen under scrutiny, not a criminal defendant. And this is where public commentary often breaks down. People assume that if someone is talked about, investigators must know something. Sometimes they do, sometimes they don't. And even when they do, knowledge does not equal chargeability. Prosecutors don't charge people because they might be involved. They charge people because they believe they can prove involvement beyond a reasonable doubt. That gap between awareness and action is where most speculation lives. Now let's talk about why silence is being misread so aggressively. When a case reaches the point of arrest, anyone connected to it enters a different risk environment. Statements made after that point don't just express opinion. They create potential evidence. Even statements meant to deny wrongdoing can be used later to test consistency, to establish knowledge, to establish timelines, to establish what someone claims they knew and when. That's why attorneys advise silence. Not because silence protects guilt, but because speech creates exposure. So when Carroll says he isn't allowed to tell you anything, that is not coded language. It is literal. It is a recognition that the rules have changed. Before an arrest, talking can be messy but survivable. After an arrest, talking can be reckless. And here's the part people miss. Silence doesn't just protect the speaker. It protects the integrity of the process. Public commentary can taint witness pools. It can distort recollections. It can create contradictory narratives that complicate testimony. Investigators don't want that. Prosecutors don't want that. Judges don't tolerate it, which is why restraint becomes visible after arrests, not before. Now, let's address the phrase that keeps being weaponized. I'm not perfect, but I care about people. Some commentators have framed this as an implicit admission, as if acknowledging imperfection equals acknowledging criminality. That's not how law works. That's not how language works. People under pressure often speak defensively. They emphasize intent. They appeal to character. That doesn't mean intent overrides outcomes, but it also doesn't mean outcomes are proven. Courts do not infer guilt from self-reflection. They infer guilt from acts that meet legal elements. And that brings us to the most important misconception. People keep asking, if Carroll isn't guilty, why doesn't he just say so plainly? Because saying so plainly doesn't help him. In fact, it can hurt him. Public denials can later be challenged. Statements can be parsed. Wording can be scrutinized. Silence avoids all of that. So when you see someone step back instead of step forward, that's not collapse. That's containment. Now let's talk about what investigators can actually do with someone in Carroll's position. They can interview him voluntarily or under subpoena. They can request records. They can test statements against evidence. But they cannot charge him unless they can tie him to specific conduct that violates specific laws. And that's the barrier people keep ignoring. Being emotionally adjacent to a case is not illegal. Being socially adjacent is not illegal. Being criticized online is not evidence. Only actions matter, which leads us to the phrase, person of interest, even when it's not formally used. That phrase has no fixed legal meaning. It's a media shorthand, not a charging category. It can mean anything from we talked to this person to we are still evaluating this person. It does not mean charges are coming. It does not mean charges won't come. It means nothing more than this person is on the radar. And being on the radar is not rare in cases of this scale. It's normal. Now let's confront the most emotionally loaded accusation head-on. The idea that Carroll's statement is an admission of guilt. It isn't. An admission of guilt requires acknowledgement of conduct that meets criminal elements. Saying I've been attacked, I can't speak, or I care about people does none of that. At most, it shows distress. At most, it shows fear. At most, it shows frustration. Those are human reactions, not legal ones. And here's where harm compounds. When people label statements like this as confessions, they raise the temperature of everything. Witnesses become hesitant. Families retreat. Cooperation slows. Justice does not accelerate under pressure. It fractures. Which brings us to Patrick's custody status, because this is where speculation has turned into assumption. Patrick remains incarcerated. Bond has not been posted. And into that silence, theories rushed in. Unsupervised probation. Violation holds. Old charges reactivated. Some of those scenarios are possible in abstract terms. But without court documentation confirming probation status, conditions, or violation filings, they remain unverified. And here's the key rule. Unverified explanations are not updates. They are guesses. Responsible analysis does not promote guesses. Probation violations are complex. They depend on conditions, jurisdictions, timelines, and judicial discretion. Some violations result in immediate holds. Others do not. Some allow bond. Others suspend it. Without filings, you cannot know which applies. So when people confidently declare why Patrick hasn't been released, they are not informing you. They are filling uncertainty with certainty. And certainty without evidence is misinformation. Now let's return to the collateral damage Carroll describes. Threats, harassment, children targeted. These are not side issues. They are consequences. And they are consequences that courts take seriously when they appear to interfere with proceedings. Witness intimidation, even informal, even online, can become relevant. It can alter how cases are handled. It can trigger protective measures. So when people justify harassment as holding people accountable, they are misunderstanding accountability. Accountability happens in court. Harassment happens in chaos. And chaos helps no one except people chasing engagement. So where does that leave us at the end of part 2? With clarity about roles. Carroll is uncharged. That matters. His silence is strategic. That matters. His statement is emotional, not evidentiary. That matters. None of this proves innocence. None of this proves guilt. It proves only that the legal process has boundaries, and those boundaries are being ignored online. In part 3, we're going to examine the speculation around probation, bond, and detention. What actually happens when someone is arrested while under prior court supervision? What can trigger holds, and why silence from authorities is not unusual? Because understanding this case requires understanding how procedure works when pressure is high and information is limited. And right now, limitation is being mistaken for concealment. That mistake is costly. Truth does not come from filling gaps. It comes from waiting until they close. This is the point where speculation has done the most damage. Because when someone is arrested, bond is set, and release doesn't immediately follow, people rush to explain the gap. And when official explanations aren't publicly available in real time, the internet fills the silence with certainty. That's what's happening here. So let's slow this down and talk about what actually happens when someone is arrested while they may already be under court supervision, and why continued detention does not automatically mean something dramatic or hidden is occurring. First, let's establish what we know and what we don't. We know Patrick was arrested. We know bond was set. We know he remains incarcerated. What we do not have, at least publicly, is a confirmed court filing explaining why bond has not been posted or why release has not occurred. Everything beyond that is inference. And inference is where people start getting into trouble. So let's talk about probation, because that word alone has been used to build entire narratives without documentation. Probation is not one thing. There is supervised probation, unsupervised probation, conditional probation, deferred sentences, suspended sentences, and probation tied to prior convictions with remaining time attached. Each of those comes with different rules. Each of those has different consequences when new charges appear. And critically, not every probationary status automatically blocks bond on a new case. That's the first myth. Being on probation does not mean you can't have contact with the law in the way people describe online. Probation conditions vary. Some prohibit new criminal conduct. Some prohibit specific types of conduct. Some require reporting. Some are limited to specific offenses. A parking ticket does not automatically violate probation. An arrest does not automatically revoke probation. What matters is whether a judge finds a violation of conditions, and that requires procedure. Here's how that usually works. If someone on probation is arrested on new charges, the supervising authority, often a probation officer or court, may file a violation report. That report is then reviewed by a judge. The judge decides whether to issue a hold, revoke probation, modify conditions, or take no immediate action. That does not happen instantly, and it does not always happen publicly. Sometimes a probation hold is placed administratively and later reviewed. Sometimes it requires a separate hearing. Sometimes it does not occur at all. So when people say, he must be on probation and that's why he can't bond out, they are guessing, unless they have the filing that says so. And as of now, no such filing has been publicly cited. Now let's talk about bond itself, because this is another area where misunderstanding is driving assumptions. Setting bond does not guarantee immediate release. Bond sets the conditions under which release may occur. It does not force release. There are multiple reasons why bond might not be posted immediately, even when someone is eligible. Financial logistics, property verification, surety approval, administrative delays, additional holds unrelated to the new case. None of those imply guilt. None of those imply secret charges. They imply process. And process is slow by design. Now, let's address the claim that if there was time attached to an old charge, he might have to do time now. That statement is incomplete. If someone has a suspended sentence with remaining time attached, a probation violation can result in that suspended time being imposed. But that requires a finding. It requires a hearing. It requires judicial action. It does not happen automatically because of internet speculation. And here's the critical part people overlook. Those proceedings are often separate from the new criminal case. A probation violation hearing is not the same as a criminal trial. It has different standards, different timelines, different disclosures. So even if a probation issue exists, it may not be publicly visible yet, and it may not resolve quickly. That's not secrecy. That's jurisdiction. Now let's talk about why authorities often say nothing during this phase. Because explaining detention reasons publicly can backfire. If a probation issue exists and is still under review, public statements can prejudice that review. If administrative holds are being resolved, public speculation can misstate facts. If multiple courts are involved, coordination takes time. So silence here is not avoidance. It's caution. Now let's step back and address the emotional driver behind all of this. People want certainty. They want to know why someone is still in jail, because uncertainty feels like injustice. Either injustice against the accused or injustice against alleged victims. But the legal system does not prioritize emotional clarity. It prioritizes procedural accuracy. And accuracy often requires waiting. This is where the contrast between commentary and courtrooms becomes stark. Online, explanations are instant. In court, explanations are filed. Online, conclusions are rewarded. In court, conclusions are punished if premature. So when you hear confident explanations about probation violations, automatic holds, or hidden charges, ask one question. Where is the filing? If the answer is, I heard, it sounds like, or people are saying, then it's not information. It's inference. Now let's connect this back to Eric Carroll's statement. because this is where the two threads meet. Carroll describes a situation where accusations have spiraled beyond evidence, where silence is misread as guilt, and where speculation has harmed his family. The detention speculation around Patrick is the same pattern. A lack of immediate explanation is being treated as confirmation of worst-case theories. But legally, the absence of explanation often means the explanation is procedural, not dramatic, which leads to a critical warning. When speculation hardens into belief, it becomes resistant to correction, even when facts emerge later. If Patrick is released after an administrative delay, people will say it was favoritism. If a probation issue is clarified, people will say it was hidden. If no probation issue exists, people will say it was covered up. That's the trap of premature certainty. And it harms everyone involved, including alleged victims, because it distorts reality. Now let's talk about what would matter if a probation violation were confirmed. If a court formally fined a violation, that becomes part of the record. If time is imposed, that becomes part of the record. If bond is revoked, that becomes part of the record. Those are facts. Until then, everything else is noise. And here's the final point most people miss. Detention status does not predict case outcome. People are detained pre-trial and later acquitted. People are released on bond and later convicted. People resolve probation issues and still face new charges. Custody is about control, not conclusion. So when people read detention as destiny, they are misunderstanding the system. And that misunderstanding feeds exactly the kind of misinformation Carroll described, the kind that feels righteous but proves nothing. So where does this leave us at the end of Part 3? With discipline, we wait for filings. We distinguish process from punishment. We refuse to turn uncertainty into certainty just because it's uncomfortable. Patrick's continued incarceration may have a mundane explanation. It may have a complex one, but until it's documented, it has no evidentiary value. And that restraint matters, because the moment facts appear, they will matter more than all of this speculation combined. In Part 4, we'll step back and examine the bigger picture, how online narratives interfere with active cases, how statements get distorted into admissions, and why public pressure often delays, rather than accelerates, accountability. Because right now, the loudest voices are not the most accurate ones. And accuracy is what this case needs most. There's a moment in every high-attention case where the facts stop being discussed and the story takes over. That's where this is now. Not because there isn't real harm involved. Not because accountability doesn't matter. But because speculation has begun to replace verification. And that shift has consequences most people never see. So in this part, we need to talk about something uncomfortable but necessary. What happens when public narratives run ahead of evidence, and why that doesn't speed justice up, it often slows it down. Let's start with the most common misunderstanding. People believe pressure forces action. They believe louder outrage equals faster arrests. They believe viral certainty equals prosecutorial confidence. They believe attention corners the system into doing something. That's not how courts work. In reality, pressure often makes prosecutors more cautious, not less. Because once a case becomes public theater, every step is scrutinized. Every filing is parsed. Every decision is second-guessed. And that raises the cost of mistakes. Prosecutors know this, which is why they do not escalate cases just to satisfy momentum. They escalate only when they are confident escalation will survive attack. Now let's talk about statements, because this is where distortion has done the most damage. When Eric Carroll posted his message, it was not a legal filing. It was not testimony. It was not evidence. It was a personal response to pressure. But online, it was immediately reframed. Not quoted in full. Not analyzed carefully. But repackaged with an interpretive headline, "I'm guilty." That reframing did not come from the text. It came from the audience. And once that label stuck, everything else was filtered through it. This is how confirmation bias operates in real time. People stop asking, what does this actually say? They start asking, how does this confirm what I already believe? And that's the moment analysis ends. Now let's be precise. There's a difference between a statement that admits guilt and a statement that acknowledges pressure. One has legal consequences. The other has emotional ones. Courts only care about the first. But online spaces collapse those categories constantly. Someone says they are overwhelmed. It becomes they're cracking. Someone says they can't speak. It becomes they're hiding something. Someone says time will tell. It becomes they know the truth is coming out. None of that is evidence. All of it feels persuasive. And that's the danger. Because persuasion without proof doesn't just misinform the public. It contaminates the environment in which evidence must later be evaluated. Witnesses read comments. Potential witnesses hesitate. Memories are influenced. Motives are assigned retroactively. That's not speculation. It's documented in legal psychology, which is why attorneys often warn clients to disengage completely once narratives take off. Not because narratives are true, but because they are powerful. Now let's talk about the phrase people keep using as justification. People need to be held accountable. That phrase sounds righteous. It sounds protective. It sounds necessary. But accountability does not mean acceleration. Accountability means adherence to standards. If prosecutors move too fast and overcharge, defense attorneys gain leverage. If they rely on public sentiment instead of proof, cases weaken. If they respond to pressure instead of evidence, they risk collapse. And collapse doesn't just free defendants. It closes doors. Once charges fail, they are harder to refile. Once evidence is excluded, it's often gone for good. Once credibility is damaged, it doesn't regenerate. So when people demand speed over precision, they may be undermining the very accountability they claim to want. Now let's connect this to Patrick's detention status. Silence from authorities has been interpreted as secrecy, corruption, or incompetence. But in most cases, silence simply means there is nothing ready to say. Courts do not issue press releases explaining administrative delays. Probation matters are often handled in separate proceedings. Inter-court coordination does not happen on social timelines. So when people invent explanations to fill that silence, they aren't uncovering truth. They're creating noise. And that noise becomes hard to correct later. If Patrick is released after a delay, some will claim favoritism. If a probation issue is clarified, some will claim concealment. If no probation issue exists, some will claim erasure. Once a narrative hardens, facts have to fight uphill. That's the cost of premature certainty. Now, let's talk about the people least protected by all of this. Children. Carroll mentions his kids being dragged into the situation. That detail should have stopped everything, regardless of where anyone stands on guilt or innocence. Children are not parties. They are not witnesses. They are not shields or leverage. When they become targets of harassment, something has already gone wrong. And here's the legal irony. That kind of behavior can actually complicate prosecutions. Claims of witness intimidation, even informal, even indirect, can trigger defensive measures. Protective orders, sealed proceedings, reduced transparency. So the very people demanding visibility can cause the system to pull back. This is not hypothetical. It happens. Now, let's address another belief that keeps resurfacing. If he's innocent, he should fight publicly. That belief comes from storytelling, not law. In real cases, public fighting rarely helps. It creates inconsistent statements. It creates sound bites that can be replayed. It creates opportunities for mischaracterization. The smartest move legally is often to say as little as possible, even when that feels unfair. Silence is not surrender. It's insulation. And this applies to everyone in the orbit of a case, not just defendants. Now step back and look at the pattern. An arrest occurs. Attention spikes. Silence follows. Speculation fills the gap. Speculation hardens into belief. Then, when real filings appear later, they're judged not on their merits, but on how well they match expectations. That's backwards. Cases should shape narratives. Narratives should not shape cases. But online, the reverse often happens. And that's why this phase is so critical. Because once discovery closes, once motions are filed, once hearings occur, the record will speak, whether it matches public belief or not. And when it does, some people will be disappointed. Not because justice failed, but because expectation was built on assumption. So what should responsible observers do right now? They should slow down. They should read filings, not reactions. They should resist turning emotion into evidence. And they should recognize that restraint is not indifference. It's respect for process. Now, let's end part 4 by returning to the central question that keeps getting lost. Does any of this mean Eric Carroll is guilty? No. Does any of this mean he is innocent? Also no. It means the case has boundaries. And those boundaries are being ignored online. Does Patrick's continued detention prove more is coming? No. Does it mean nothing is coming? Also no. It means the system is moving at its own pace, not ours. And that pace exists for a reason. Because once the system speaks definitively, it cannot unsay what it has said. So if you care about truth, not just resolution, this is the moment where patience matters most. In part 5, we'll close this series by laying out what actually signals movement from here on out. What documents, decisions, and milestones tell you the case is advancing, narrowing, or stalling. Not speculation, not vibes, actual indicators. Because when the noise fades, those are the only things that count. From this point forward, the case won't be decided by statements, speculation, or social media certainty. It will be decided by paper. Watch for filings, not reactions. Amended charges, not edited clips. Hearing dates, not rumor timelines. If prosecutors expand, it will appear in formal documents. If they narrow, it will appear in dismissed or refined counts. If nothing changes for a while, that doesn't mean nothing is happening. It means preparation is. Silence from Eric Carroll or others is not proof of anything. It's procedure. Truth in cases like this doesn't arrive loudly. It arrives officially. And when it does, it won't need interpretation.